What's up, everybody? It's Peter Tragos, the lawyer you know, and on this channel, we break down the trials and cases you care most about so you can understand how the American civil and criminal justice system works. And we try to make sure you understand what your rights are in every situation, which is why we try to walk you through the entire legal process while also answering your insightful questions along the way. And while it's not legal advice, it's always exciting. So buckle up for another episode of The Lawyer You Know. What's up, everybody, and welcome back in. We're talking Lori Vallow Daybell today. It's been a little while, and a bunch of you sent me her motion to dismiss for lack of speedy trial. We're going to read through that together today and break it down and talk about, have her constitutional rights been violated? We've talked speedy trial a lot. In most cases, it gets waived, but there are some cases where defendants sit in jail for years and years and years, and their rights are stomped on, and their rights are violated, and there is no good reason or cause for them to be sitting there like that, except for our criminal justice system just forgets about them or doesn't care about them. And we'll talk about whether or not this is one of those cases. Now, we know there's been a lot of different reasons for delays, a lot of moving parts in this case, so we're going to break it all down together as we read this motion. So if you're interested in this case, hit that like button, hit that subscribe button, hit the reminder bell so you don't miss any future videos on this case. We're still covering Alec Murdaugh. That's going to be tonight, 8:30 p.m. EST live to answer your questions. I'm going to try to be in the chat during this video. If you have questions, to throw them in the chat. But as we sit here today, this motion has been filed. So let's look at it together. All right. So here we go. Motion to dismiss for lack of speedy trial. Comes now, the defendant, through her attorneys and pursuant to the Constitution of the United States, Amendment 6, and the Constitution of the State of Idaho, Article 1, Section 13, and Idaho Code 19-3501, and moves the court to dismiss the case as the government has violated her right to a speedy trial as follows. So, multiple rights that we hold true and very important. Here we go. The accused shall enjoy the right to a speedy trial, Constitution of the United States. The accused shall have the right to a speedy trial, Constitution of the State of Idaho. The term speedy trial does not specify the length of time required to bring an accused to trial. Federal law enacted a timeline for someone charged with a federal crime, and each state in the union enacted laws to define what it means in their respective state. So as you can tell right off the jump, it can be a bit of a gray area. There's no, on day 21, if this trial hasn't happened, boom, dismissed. There's all sorts of factors that we have to balance to determine whether or not the speedy trial rights have been violated. There's a case called Barker that you learn about in law school. There are some really sad cases where people have been in prison for more than 10 years waiting their trial. But I wrote a paper on it in law school. But we're going to get to those Barker factors. But first, there's a couple other cases in Idaho codes we're going to get to here. Idaho legislature defines speedy trial in Idaho Code 19-3501 as follows. The court, here we go. Unless good cause to the contrary is shown. I'm going to highlight that every time we read about speedy trial. Unless good cause to the contrary is shown. And we're going to talk about what that might be in this case. Must order. So if they don't find good cause, they must order. It's all this if, then, but the ifs are gray areas. Like, what's good cause? Do we have a definition for it? It's like, but it says must and it says shall. So that says the court has to do it, right? Well, yes, they have to do it. Unless good cause is shown. The Florida Supreme Court is throwing down all these rules at us right now. We've been taking so much time reading through them, changing them on the Civil Rules Committee that I'm on. And so much of it comes down to the court shall, the court must, using language like that. But then when you throw the unless clause in there, it gives them an out. So they always have an out. If they say, oh, this is good cause. Now, it could be an appellate issue, but all right, must order the prosecution or indictment to be dismissed in the following cases. If a defendant whose trial has not been postponed upon his application, meaning if you ask for a continuance as the defendant, you waive your right to speedy trial. But, and that his can be his or her, Lori Vallow has not done that in this case. So, if a defendant who has not asked to postpone the trial is not brought to trial within 6 months from the date that the defendant was arraigned before the court in which the indictment is found, We're going to get to all the dates in this case later in the motion. In State v. Clark, 135 Idaho 255, the Idaho Supreme Court took up the speedy trial issue and the determination of good cause. Here we go. The determination of good cause. How do we determine what good cause is? Upon careful consideration of the relevant authorities, we believe that a thorough analysis of the reasons for the delay represent the soundest method for determining what constitutes as good cause. We therefore conclude that good cause means, here's what they think it means, that there is a substantial reason that rises to the level of a legal excuse for the delay. Great. We've defined a term with more terms that need definitions. What is a substantial reason? And then what rises to a level of legal excuse for delay? Literally, we just go round and round about this stuff, and I can't even explain to you what it's like. These words give me nightmares thinking about how many I've gone over. Again, same thing. What does substantial reason mean? What is good cause? What is a good excuse? The matter is initially left to the discretion of the trial court. So that's what it comes down to. So many things are left to the discretion of the trial court. That's why you go to judicial school. That's why you learn how to be a judge. You learn from experience. You learn from being a lawyer. Because at the end of the day, we can read all the rules. We can read what the case law says. But at the end of the day, it comes down to what the trial court judge thinks is the right thing to do. And we've already had that determination in different ways in this case. Talking about cameras and microphones in the courtroom, talking about severing these trials, talking about continuing them and when to continue them too. The good cause determination may take into account the factors listed in Barker v. Wingo. This is the Barker case. The Barker factors, however, considered only as surrounding circumstances are important, if at all, only insofar as they bear on the sufficiency of the reason itself. The shortness of the period, the failure of the defendant to demand a speedy trial, and the absence of prejudice are legitimate considerations only insofar as they affect the strength of the reason for the delay. So, how quickly do they demand speedy trial, and how prejudiced are they? Meaning, how much does this hurt their case that they didn't get a speedy trial? This means that to whatever extent the delay has been a short one, or the defendant has not demanded a speedy trial, or is not prejudiced, a weaker reason will constitute good cause. So, if they took a while to demand speedy trial, a weaker reason could be good cause. If they demanded it right away, you need a better reason for good cause. If they're not really going to be prejudiced with the delay, you don't really need that good of a cause. And believe me, you don't almost need any cause at all if the court doesn't feel they're going to be prejudiced by this delay. But if they do feel like there's a major prejudice for this delay, then you need a really, really good reason to make it good cause to not dismiss the complaint. And we'll balance all this in this case. On the other hand, if the delay has been a long one, or if the defendant has demanded a speedy trial or is prejudiced, a stronger reason is necessary to constitute good cause. Thus, the ultimate question of whether legal excuse has been shown is a matter for judicial determination upon the facts and circumstances of each case. A trial judge does not have unbridled discretion to find good cause, but they kind of do. However, and on appeal, we will independently review the lower court's decision. So they're saying, if you don't give a speedy trial, we will appeal based on this. Fine. The following is the timeline against Lori Vallow Daybell. On February 20th of 2020, she was arrested in Hawaii on $5 million bond. On May 25th of 2021, the indictment from the grand jury, but the previous two cases were dismissed and no bond. Again, this is when we got to murder. She was arraigned on the indictment April 19th of 2022. Now, this is kind of the date we start counting from, because as we know, there was a 6+ month delay dealing with her competency. Okay. And let's take all this into account, because they're going to try to make this sound like a longer time, talking about February 20th, how long she's been in jail. The previous charges she was initially charged with, those went away so they could bring the new indictment on April 19th of 2022, which were the murder charges. So that's kind of where we're starting. They already dismissed the older ones, so we don't count from the February 20th or the May 25th date, because those have been dismissed. So the indictment she was arraigned on, where we're starting our clock, is April 19th. When was her competency? Let's see. Competency, Lori Vallow. I know it was May to November, but now I'm trying to remember. So it was May to November of 2021, right? Let's see here. do some research together. All right. Lori Vallow is again competent to stand trial. It's right before April, so it must have been, November 9th, 2022. Okay. So April, she's indicted. May, she's found to not be competent to stand trial. So from May to November of 2022, she's not competent to stand trial. So that does not count in this speedy trial delay. You can't use that as the delay to speedy trial because she can't help with her defense. So how are you prejudiced giving her time? Now, defendants have argued that, and they even kind of make mention of it in this case, but it's not going to be a valid argument that the trial court's going to say, yes, they violated her speedy trial because she wasn't competent for 6 months in between. So that's just not how it's really going to work. But October 11th, the first trial setting on the indictment. So that was the first time they actually set the trial, was for October 11th. The second trial was set on January 9th. The third trial was set on April 23rd. And we know that throughout all this, what's very difficult, and again, they list here 1,169 days in jail without a trial in any of the three cases. Well, they've already dismissed 2 of the cases, so you can't argue that, right? So going all the way back there is just kind of inflating the number, but that's okay. They're trying to prove the point. She's been in jail for so long and never had her day in court. Fine, that's legitimate. That's totally legitimate. However, we know there are a lot of moving parts, and this is why I said from the jump, I think the judge should have severed these 2 cases. Let Daybell do whatever he's going to do. Let's get Lori Vallow tried now. She wants a speedy trial. Let's try her. Spend plenty of time. But now that the court has decided to keep these cases together, and I will just tell you, that should give you an indication onto what he's going to rule here. The judge is not stupid. He has considered these factors, and he still decided to keep those cases together. That's why he didn't pick Daybell's date, probably, which was late 2023, and instead set the case on April 3rd of 2023. He was probably thinking about this. But again, they can make this look like almost a year since she was indicted, April 19, 2022 to April 3rd, 2023. But all that time she was found to not be competent, plus they questioned her competency again. The judge is going to rule that that's a good cause for the delay. That's a legal excuse that allows the government to not have to dismiss this case based on speedy trial. And this is where we get theoretical and reading the rule, and it says 6 months, but then it says, but good cause. And that's why we have to do the analysis of what's going to happen in real life. Not just what something says, not just what some statute says, not just what some law book says, but we've got to take the totality of the circumstances here. And there are other things we're going to talk about. I actually want to talk a little bit more about, can Murdaugh be charged with conspiracy to commit murder after this murder charge, because the law books may be different than what would ever happen in real life. All right. The first trial setting, here we go, paragraph 7. The first trial setting in this instant case was for October 11th, 2022, since that was within 6 months of April 19th of 2022. The government then asked for more time, and the court granted the request and set trial for January 9th. This violated a right to a speedy trial, but they didn't file this back then. Okay. And the reason was, we all know, the competency issue. The competency issue is the reason for a lot of these delays. Lori Vallow's defense team questioned her competence to stand trial, and the court told the case from October 6th to November 15th of 2022. A 40-day delay caused by the competency review still doesn't justify a trial setting 3 years after her arrest and almost 1 year after being arraigned. The government still has an obligation to bring her to a speedy trial, which complies with the constitutions and the Idaho Code. From her arrest on February 20th of 2020 until her current trial setting on April 3rd, 2023 is 1,169 days without a trial in any of the 3 cases. From her arraignment in this case on April 19th of 2022 until the current trial setting of April 3rd, 2023 is 349 days, obviously more than the statutory 6-month time limit. Her constitutional rights, including her right to be presumed innocent and her right to a speedy trial, have been ignored by the government. It is undisputed that Lori Vallow Daybell has demanded her speedy trial and has never waived her constitutional rights. She is prejudiced every day since she's in jail and unable to post a bond. The court has repeatedly reminded the government that it will respect her constitutional right to a speedy trial. The government cannot show good cause to bring Lori Vallow Daybell to trial over 3 years from her arrest and almost 1 year from her arraignment. This court should find that the government has not met its burden to uphold her constitutional rights. This case should be dismissed. Okay? So they want this case to be dismissed based on Lori Vallow's speedy trial rights. Looking up something else that I just think is interesting. So when we talk about, the competency issues, technically it doesn't say that if they're found not to be competent, it gets to be more than 6 months. But that's why we leave the discretion to the trial court. So when I'm thinking about how Judge Boyce is going to make this determination, he is going to consider, and I guess I can pull this off the screen now. He is going to consider, actually, I'll just make it smaller. He's going to consider a few things. He is going to consider the competency issues. He is going to consider combining the case with Chad Daybell. He is going to consider how much money it would cost to try these cases twice. All of the things we talked about that were judicial discretion in severing the cases, he's also going to consider here as being a showing of good cause, a legal excuse for the delay. And there's all these different balancing factors, right? So if we're going to talk about how long the delay is and how much she's going to be prejudiced, let's just balance those factors here together for a second, okay? So number one, how long is the delay? Well, I'm going to look at it how I think Judge Boyce is going to look at it, which is the April arraignment date, which has been 349 days according to this document. So if about 6 months of that, she wasn't competent, 6 months plus 40 days where the defense said she may not be competent, was this a delay tactic for them? Were they trying to get it to go past her speedy trial? Well, if we take that, it's about 7 months of her not being competent, or at least her competency being questioned, which would then put us right around in the 6-month mark for this April trial date. So the judge could say the length of delay is not really that far outside the 6 months that she was actually competent to aid in her own defense and to talk to her attorneys about her case. So I think that's probably a good enough cause shown. Then number two, the reasons for delay. The reasons for delay was her co-defendant and co-conspirator asked for a continuance. And the judge, who found good reason and good cause to not sever the cases, balanced the interest of justice in allowing Chad Daybell to continue the case to April, not to October or whenever he wanted to of 2023. So a lot of these things have already been considered by the judge, in my opinion. And I think he's going to deny this motion to dismiss based on speedy trial for Lori Vallow Daybell. I do not think he's going to allow this case to get dismissed. And I think those are the factors he's going to focus on. The co-defendant and the reasons for keeping the cases together, the timing, the money that the state's going to have to put out, the publicity, all of that stuff, I think he's going to say is a good reason for this delay. And then how long has the delay actually been based on when she's demanding speedy trial? With all of the competency issues, it really hasn't been that long. So I think as he balances these Barker factors, I think Judge Boyce is going to come down, deny it. But where it's really going to get fishy and really going to get interesting is if Daybell asks for another continuance and feels like he has a good reason to need another continuance. Whether it's a new defense, or he didn't get to depose the alibi witnesses, or he needs to look through the discovery and it's just too much. It's so funny, right? One side saying, we demand a speedy trial. The other side saying, there's no way I can prepare a defense in this time, Judge. Is there some gamesmanship? We know that the defendants filed a motion so that they could get together and talk, and the judge said no. Are they planning and plotting this joint defense where it's actually opposite defenses to try to sever these cases? I want a speedy trial. I need a continuance to prep for trial. They're at odds with each other at this point. And could it potentially help each other? Is that a sign of things to come? If there are two trials, are they going to try to help each other in working together in these defenses? Interesting to think about. So many things going on in this case, but I truly believe that the competency issues and the reasons for delay and the factors already considered in not severing the cases are where Judge Boyce is going to land on using his discretion to deny this, but I don't think he's going to grant any more continuances past April. And I think Daybell's lawyer should probably put the pressure on him to try and get another continuance to make him make a call. Because if we continue it again, are her speedy trial rights going to continue to be violated? Because once it gets out of 6 months where she was actually competent from April to the trial date, now we get to a bit of a different argument. So those are some of the factors I would be looking at. What's the judge going to do? The judge could dismiss it. It's within his discretion to dismiss it. Frankly, it's been longer than 6 months technically, and it says must. But is there a substantial reason? Is there good cause shown? Is there a legal excuse? I think there is. Let me know what you think in the comments. Do you think the judge is going to dismiss it? Do you think enough good cause has been shown to try this case and not dismiss it for lack of speedy trial? I want to know what you guys think as usual. So let me know in the comments and hit that like button if you enjoyed this video. I'll see most of you tonight on the live.